Time again for Let's Talk Legal. Compliments of Neumann van Rooyen attorneys. And once again, we have Marié Combrink with us here in studio, chatting a bit more about fair, wear, and tear, and what is really the meaning of these words in legal agreements. Now, Marié, once again, thank you for joining us in studio.
Thanks. Looking forward to having a new discussion.
So this is a fairly common phrase that people use, I believe, but what does it really mean? Because the meaning of fair has a different meaning for different people, of course.
Yes, definitely. We all differ. We actually attended to a few personal ID tests the last few months. So yeah, people definitely differ. And therefore, it is important for us to understand especially what the wording refers to. And I think in this instance, because we're talking about legal agreements, to enable a more general and common understanding, which can result in a more general understanding for all and just give a general, a way or a rule for us to assist. So I thought for this instance, let's have a look at lease agreements of property as an example to assist in explaining and understanding what the wording means in these type of legal agreements and also the implications. Wear and tear generally refers to the deterioration of the condition of the leased premises in this instance, which is caused by normal everyday use of the property while you are in use of the premises. Even though we are limiting the discussion to lease agreements for today, the accepted norm can still differ depending on the type of business the tenant conducts from the leased premises or if the premises are used for residential purposes.
Now, do you have some examples for us as to what fair, wear, and tear actually refers to?
Yes, the most common example is damage or deterioration of the property due to weather conditions, which is unavoidable, and also we don't know when is going to happen. For instance, like even the sun, rain, hail, and wind causing paint to change color, for instance, or split from the item that it is painted. This is a common cause and easy to identify as an owner of a property. Normally expect that this causes or requires regular repairs or maintenance of a property. It is also when deterioration or damage is caused, but not due to the tenants or the visitors acting in a negligent manner or damaging the condition of the structure of the property on purpose. It is an accepted norm, and the deterioration in this instance is the responsibility of the owner of the property, and it is also expected due to normal daily use of the property.
Now, what will then be good examples of what is not accepted as fair, wear, and tear to premises?
Well, examples of deterioration not being fair, wear, and tear is when the damage to the premises are caused by negligent or accidental destruction or damage to the leased premises. Some good and simple examples are a carpet being ripped while furniture is moved around in the property, stains in the carpet which cannot be removed even after professional cleaning has been attempted, nails or everything that you use to maybe put up pictures, some glue or anything that damages the walls. And then also some tenants want to paint a wall a different color, and that is not what it's originally looked like when they took occupation of the property without the consent of the owner. That's very important because sometimes the owner feels that it improves the property and they're fine with it. Mm-hmm. Another simple example is the tenant's children play cricket in the yard and the ball is hit through a window. So that is accidental, not on purpose, but that's for the account of the tenant. All of the above are examples which require the tenant to restore the property to the condition it was received in, or they can forfeit a portion or maybe the whole deposit in order to return the leased premises to its original state. It is always a requirement that the premises be returned to the owner as close as possible in the same or in a better condition when vacating as what it was received in, with exception of fair, wear and tear, which is unavoidable by the tenant.
Now, attorneys always refer to what the court takes into consideration when judging a matter. Is there a court test in plain words for fair, wear and tear which can assist us in understanding this term?
Especially with regards to the fair, wear and tear, there are a few court cases over the years that refers to this matter. And yes, we always have to look at current and even older court cases to give us as attorneys an indication as to what legal advice we should give, as these court cases gives practical examples as to how to interpret the law in different cases but to still result in a general common ground. This also gives more certainty as to what can be expected when instituting a claim, or even when you have to defend a claim instituted against you as a tenant. Owners and managers of leased property also need to take all of these case law into consideration when they are calculating the amount of the deposit that needs to be paid back to the person that leased the property. You always have to remember that an owner that is leasing a property should always expect that the property is used and some wear and tear is bound to happen. Owners should have reasonable expectations. There's a very old court case of 1949 that is actually referred to on a regular basis as a court test. I'm not going to go into the details of the name of the court case and so forth, but just some few points that we can have a look at. Number 1, the tenant is not required or under any obligation to repair structural defects or to put the leased premises in a better overall condition than it was on the date when the tenant took occupation. Number 2, the tenant must only make such repairs as are ordinarily caused by their negligent or accidental actions, not improve the property from the state it was received in. Number 3, the courts specifically state that a tenant is not obliged to repair structural damage except if it's caused by their negligence. So somebody gets onto a roof and the tiles crack. Mm-hmm. It's very important to have proper proof of the condition of the property when you move into the property to establish that there was breach by the tenant and the repairs has to be done by them.
Now, from everything that you mentioned, it still seems to me that each and every matter should be considered on its merits. Do you have any practical advice to limit disputes as to what is fair wear and tear and what will not qualify under this term?
Yes, we always want to give advice on this, and I would really appreciate if they will take note, because for us as attorneys, this really helps to just attend to the matter in a better way. It's always important to have a proper lease agreement in place, which address most of the disputes which could possibly arise. So if you need any help with that, please contact us. A proper inspection report should be done when occupation of the property is taken by the tenant in the presence of both parties, or if you have somebody that you authorize to represent you in that inspection. And then it's good if all of these are signed off by both parties. Take photographs of any area that may become a dispute. So say there's a cracked tile already and it's not fixed when you move into the property, and that can be an issue later on. Both parties should agree as to the primary use of the property, because it all depends on what you're going to do in the property and what wear and tear will be expected. Next, regular ongoing inspections during the lease period is also advisable. Lastly, with all of the above taken into consideration, an outgoing inspection should be done in the presence of the tenant vacating and also the owner or his or her representative. That is a good place to then also agree who will be responsible for certain damage or deterioration of the property, and then whichever party can accept what is their responsibility. I know it always seems like a lot of administration and it's time consuming, but at the end of the day, a court case to determine or settle these disputes can be more time consuming and money consuming in most instances.
Absolutely. Marié, once again, thank you so much for joining us in studio and really shedding light on something that I think is very, very important.